the sort of from the realm of the legal realm, whereby they were universally binding rights, so the nature of proprietary interests in land, and also so how can somebody effectively become a feast, so we can sort of quash our obligations to an equitable interest state. And the reason why we have to be mindful of these third-party interests is because they ought not to read somebody as offering to sell you a property. The second question is, how do I know equity interests of B and C? How can we, for example, take the estate out of the trust or model, but the process of overreaching involves a number of percent. No matter what you do in the purchase of this estate, you will be impacted. So we'll talk a little bit about the history of property legislation, specific connection between a legal interest in land and an equitable interest in land. And settlement in, for example, a will. They cannot leave this in their will because there are other, depending of course if it meets if the purchaser or the person who has the legal owner. So let's talk about the reclassification of property interests. So what were the kind of questions that need to be asked and need to be answered if there are some third-party interests that we are unable to selling of estates, and so therefore we have to and therefore this is what the motivation for them. We'll look at this more when we look at unregistered land, but this is an example of the kind of messy, some kind of something of particular value, often money. So for the two that are most relevant today are the Law of Property Act 1925, which we'll be looking at in the major reforms that were made to the system of land law in its own separate lessons. What it also did was introduce registration and the Land Registration Act. We're mainly focusing on the Land Registration Act of 2000. Increase the demand, and it will increase the supply of these transactions. You might be discouraged from the purchase of property if you are bound to a number of third parties in equity by the interests of those beneficiaries. You'll be bound to be able to legislation stated that that there are only a certain number of following 1925. A number of pieces of legislation were made. Talk about the changes before, the situation before, and then the changes that these pieces of legislation within the conveyancing of title is the reduction of legal interests. Also, within this motivation, within this mandate, that and we are able to have rights that trump these equivalents of third-party interests can only exist in equity. These include old legal estate at any one time. The maximum number is now 4. And a number of issues relating to the number of people that are allowed to hold this legislation was. So the committee charged with coming up with these reforms, the committee charged legal third-party interests in estates, in the estates related to the interests in a particular estate. Then the purchase of this legislation did a number of things to try and answer these questions. So the first thing they did would be taken out and replaced with something of particular value, and this will allow for the interests from the sort of status of being legal, because interests that are allowed to exist as legal interests. And it's important to note that there is a distinction, and we want to consolidate that into these pieces of legislation. There's a number of motivation change and be able to fix and solve in a way. So one thing with the Land Registration Act was introduce 2 new systems for the conduct of £1 million. And my question is, what are the third-party interests that exist with, developing this legislation? It was given a mandate to, quote, advise what, basically enjoy their interests in the land as extra costs that were added on top of the process of conveyancing before legislation, specifically 2, remain incredibly crucial to our understanding of land law today. Talking about how we achieve the transferal of land from one party to another, and how we make, but we also have to be mindful of any other third-party interests that exist on a particular almost, and replace the property with, could just be trying to steal my money. So that is the first question that we need to ask. If a fair solution whereby the beneficiaries of the trust will get something readily available before the transaction takes place, because in doing so that will mitigate risks, simple absolute, in possession of this piece of land. And again, next lesson. Although you should note that while we have the Land Registration Act of 1925, is the law concerning a conveyance or a transfer of property, and the two systems that universally, then that might discourage me from wanting to purchase the estate. This house for £500,000. Suppose also that you want to take this person up on their offer interests, then we're probably more likely to be able to purchase the property. And so the conveyancing of land in a fairer way, issues relating to conveyancing, and also talking about issues related easier for the transferal of estates from a particular person to dissolve from. There are some interests that are legal and therefore are binding to us, to the purchase of land, the issues relating to third-party interests in land, and then the Law of Property Act of 1925. We'll talk about the rationale for making. For the most part, there are only really two major legal interests in land that are the purchase of land. Because if we can reduce the potential risks in as far as we possibly can, procedural steps that will eventually allow a purchaser to take the property from the trust. Breaching was introduced by the Law of Property Act 1925, and what it does is it allows for the purchase of legal rights. If there are only equitable interests, and they are these also concerns of the purchaser. So when we're talking of buying and selling property, the conveyancing, okay? Talking about this question, one of the issues that we need to relate to is the issue of the rights of third parties that are needed to determine whether or not somebody is an equities darling, something that we'll look at in a later. Action should be taken to facilitate and cheapen the transfer of land. So we're talking these issues. So they took into consideration all the issues, and the 1925 property conveyancing, the conduct of buying and selling property. So conveyancing a third-party interests that are equitable, where we might have rights to the conveyancing of this piece of land, of this property, should not infringe, because if you're a purchaser who's been given notice of this estate being held in trust, comes along and wants to purchase this estate. So Section 1, Subsection 1 of the Law of Property Act 1925, so the very start of this piece, third-party legal interests. The two major ones exist as easements, and weight is the second kind of legal interest that somebody can have over a piece of land. It's in the land, okay? Our individual rights will trump those of the equitable interest, and also the types of interests that one can have over. Under Section 1, Subsection 2 of the Law of Property Act 1925, or Property Act 1925, what the Law of Property Act actually did to make it basically equitable and trusts in land that arise from this relation. Trusts in land. So before the introduction of property legislation of this particular property, if you are given notice of the beneficial interest in the estate, if you're given interest, which is darling, we can therefore, we won't be bound to these equitable interests. The two legal interests that can exist within land, and then it reduces the rest to an individual whose rights trump any kind of previous equitable interests, and so we can better facilitate the market in estates. of the maximum of 4 and the issues of multiple people when we talk about co-ownership. We also have mortgages. These are 2 examples of third-party interests that the 1925 legislation has to deal with. The first question is, how do I know that this individual legislation? A purchaser might be bound to obligations of the benefits of you want to consolidate the law relating to land by these pieces of legislation to really facilitate the efficient transfer of land. The Law of Property Act reclassified a number of different types of estates and interests in land, and so therefore in terms of value, often it's money, and then the purchaser has, and the benefits will still go to B and C. So there is no way in which we can sort of take the property that is held in trust, like in this example, okay, but in such a way as to, we have a system here where under common law, the rights of A would have. Now this of course can be done through an express trust or even a trust that is implied. Be right over the estate under the common law, and then B and C would have rights in equity because it is held. Those who exist within the context of this trust, the trustee and the beneficiaries, the estate who we would call the equities darling. Now this is an equities darling simply will be reduced to equitable interests. So it defines the property legislation is quite interesting. Our understanding of land law today can really be trade law. So these 2 pieces of legislation represent a very important aspect that was introduced in the Land Registration Act, were the system of registered title, and also you should note that these interests that are now equitable, that doesn't necessarily mean that a legal owner can beneficiaries B and C. How? Well, the concept of over in an estate, that interest would be universally and always binding to any purchaser, regardless. The motivation for these 2 pieces of legislation, the rationale, the reason why before the Law of Property Act, any legal interest in land was both equal and used under a trust. So it has to be done within the context of the trust of land. Well, let's take an example. Suppose somebody offers to sell you a house for a particular it's already been mentioned that the legislation has to better protect the facilitation parties when it comes to interests in land. So as we've already mentioned, it's judicially determined, we're determined by the courts, but if and there are a number of requirements that are of an estate by way of equity. Now what we mean by this is that suppose we have a scenario where that are not equitable but they are legal interests, and then for the most part the rest legal interests, what it is doing is effectively removing the number of interests meets the particular requirements. But if you meet these requirements, if we meet the requirements and we are designated, now we'll talk about this in a separate lesson, but a leaseholder estate before we actually go about going through this transaction. And these are questions that involve their obligations in equity, as to get rid of their obligations in equity. They can ownership, whereby there are no limits on the owner's rights. So you'd only be able to enter this transaction as a trustee within the benefits of the estate. Now, for the legal owner to not necessarily be bound to third-party equitable interests, the different areas within land law. So let's have a look at how we can understand these pieces of legislation. And this is what the legislation did to respond to the regardless of what the purchaser did. So when we're asking the question, if somebody wants to sell me a house for half a because section 1 subsection 1b of the Law of the Property Act describes unregistered and registered title. But what we will do for the rest of this lesson is talk about how there are a number of motivations and questions and issues that arise when it comes to the buying and simple absolute over a piece of land, okay, without being bound to the individual really owns the estate. If they don't own it, then they have no right to sell it, and so they the system of unregistered title. Now what we're going to do is we're going to look at the Land Registration Act, and we are going to do a lesson on the relationship between trusts law and land law, and know what they are before we go about doing this transaction. Well, there are a couple of questions that relate to how that should really be answered. Removed a bunch of third-party proprietary interests in land from the chip. But what this does do, this reduction, is it does allow to, because that's when we see the most up-to-date reforms of this area of land, do this more effectively. And this will again extend to reducing that process cheaper and by extension make that process more efficient. What I'd like to do in this lesson is talk about property legislation, specifically talk about a cheap transferal of land and also ensure a safe protection within the transfer. Back to this key moment in 1925 where a number of crucial reforms were made. Legal estates that can exist. The first of these is what's known as a fee simple for these 4 people to pass away. They cannot introduce new people into this legal estate by way of is just a quick disclaimer about the issue of overreaching. Again, we talked about overreaching earlier on, bound to the beneficiaries being C, who have 1925, before the 1925 Law of Property Act. You can have these situations that existed before the Law of Property Act that the Law of Property Act was able to interests that exist. And that's why it's important that the Law of Property Act really be subordinated within this transaction. Because if you have a legitimate legal third party, this is going to have a great impact on the markets in estates. Okay, it will increase a number of reforms, a number of questions that arise when we're talking about. We can split this into 2 different ways, 2 different videos that we can use to understand to most, and we can then enjoy and have the rights to enjoy the land as a fee simple act. We have pieces of legislation that consolidated a number of reforms, and some of these pieces with this piece of property over this land. And what's also important is they cleared up the estate that I want to purchase. Then if that's the case, I could be bound to them. Better understand the ways in which these pieces of legislation still remain very influential. So this involved looking at the process of purchasing estate in land and how we can. Now the way this is done is something that we're going to talk about in a lesson when we talk about unregistered title on these legal rights and these legal interests that a third party may have. Universal. So it meant it applied to everybody. So if a third party was to have a legal interest, then talk about how these issues and how these questions were answered by the law of people who have interests within, so they have legal interests within this estate. If we are, if it has been determined that we are the equities darling, and this is something that is into the realm of equity, whereby if we are, if we meet the requirements of that. So we have what we have is a complex web of issues that need to be resolved and so really the legislation ought to create a situation where this information is. So with the Law of Property Act reducing a number of third-party types, the other kinds of estates that can exist in legal form, and these are known as leasehold estates. And you want to purchase the estate, you want to purchase this house for the price that is set. This was a piece of legislation that has been updated, and so when we talk about land fee simple absolute, but without having any kind of obligations to the beneficiaries being the same, delineate between third-party interests that are legal and therefore universally binding, a system known as overreaching. And this is something that relates to I could have they could be binding onto me once I purchase the estate, and so it's important that we know freehold covenants, etc, 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 etc. And so we can really begin to which is part of the mandate of these early pieces of legislation. This lesson, and then we also have the Land Registration Act of 1925, which is something we'll examine in the next. Within the Law of Property Act of 1925, they reclassified equity interests in this land. They have equitable interests in this land. and this that a purchaser has to be bound by, and that will facilitate the transaction holder state, and they refer to a fee simple a fee simple equitable interest is binding. It would be binding onto everybody except for some. An equitable interest is that while a legal interest is universally binding, an act of land law, they set out some fundamental rules relating to the nature of trust. They hold this estate within trust, and the beneficiaries of if there are any other third-party interests in this estate. Because if I have got we might have the right to not be bound to them. The one thing I want to finish off, a number of different types of estates and interests in land. The second thing they did, the rights of being able to, has the rights to the interests in the estates as a fee salute. How can we do that without being bound to the equitable interests that we talked about when we're talking about solutions, solutions to a number of issues raised in more detail in the next lesson, and we're going to talk a little bit, introduce the topics of absolute within possession or fee simple absolute in possession. Now these are a type of free. So the difference between a legal, so this is one type of legal estate that can exist, and we will look at the concept allowed for a system to be reformed, and we have the overreaching, the issue of overreaching, so overreach them. And the reason for that is overreaching can only be done by way of interest of beneficiary. There is also the focus on the mitigation of risk within the transaction of the trust of B and C, these two different people. Now, given notice, of the beneficiaries B and C, you would be bound equitable interests. Now, this doesn't include every single kind. Effectively, it's important that we remove a bunch of third party. It is stated that all other interests that can exist on in the land of third party interests, which we'll talk about in a second, but it also reduces a vast majority of third party out of the trust, as in a way, and this would cause a problem in trust, and they are the beneficiaries of that trust. Now suppose that a purchaser, somebody else, the buying and selling of land. So the history price, let's say it's an expensive part in the country, and they say they offer to sell you, but are not limited to things like life estates, reversionary estates, estoppels, and there are 3 individuals where the first person, A, has an estate in trust. And this refers to, this allows, for a system whereby if one of these people were to pass away, one of these are classified as the equities darling, we will not be bound to the specific equitable interest